because we are being fed with falsehood. You see, madam, be good enough to yourself and your calling as a lawyer and continue reading accordingly to the extent that the preserve to settle a matter of interpretation and
which part is reading?
Continue reading. You just stopped at the Constitution.
So the same paragraph.
So
accordingly,
the
to the extent that the exclusive preserve to settle a matter of interpretation under 2.1 and 131 and 2 lies with the Supreme Court, it is incumbent on this court to exercise jurisdiction and resolve the interpretation for the application of the High Court.
In my opening remarks, what I said,
and please, if you pay regard, but I'll just give you a second. If you pay regard to the fact that can the Supreme Court deal with matters when there are issues that the High Court can deal with, they treated it. Go to paragraph page 12 of the decision. It's so clear. And if you permit me, I'll quote. We must say that at once that the jurisdictional challenge raised by the first defendant is not novel, having been previously considered and resolved by this court in authoritative decisions as such Michael Ankuma, Nimfa, and James Kwache. Yes. If you go further down, I mean, it's like this court reiterated the settled position of law that this court's original jurisdiction under Article 2.1 is not necessarily ousted. Necessarily ousted just because there is within the same course of action a concurrent jurisdiction vested in the High Court. This is what this court, Amagate JS, said. Next page, and it continues. It means that if there is an issue to be determined by the High Court, and there's also an issue to be determined by the Supreme Court, and there's like concurrent jurisdictions, the jurisdiction of the Supreme Court is not precluded. This was stated as a principle of law with cases including the Zenato case. So, madam, if you've not read the entirety of the decision, don't come out and say that, look, the Supreme Court did not consider that there is an issue that it's only the High Court that should determine, but they have assumed the jurisdiction. You know what Justice Tanko was doing? Justice Tanko, for once, was important.
I thought he just wanted to make an answer.
You have enough time. So, just conclude, okay. And I'll put through one question. I'll come back to it.
Okay.
So just conclude. Yes.
I want to conclude that if you see Justice Tanko importing words into the Constitution by saying that it is the High Court that has exclusive jurisdiction. Go and read Article 99. There's nothing like exclusivity. The word exclusive was not used. But when you come to Article 130 of the Constitution is clear in this language that it is the Supreme Court that has exclusive jurisdiction to interpret the Constitution. So we shouldn't mess up the understanding of the framers of the Constitution that where you have exclusive jurisdiction, that word is tacked on to the provision. But where you don't have exclusive jurisdiction, it is not said.
Yeah. So I think the point really is that 99.1 says that the High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a member of Parliament or the seat of a member of Parliament has become vacant. I think the jurisdictional issue being raised here is that once the Constitution has been clear that this lies within the province of the High Court, going to the Supreme Court to get this matter adjudicated was improper. Of course, I take notice of the fact that the matter was clothed as an interpretative one. But when you look at the facts of it actually bring the issue to the province of the High Court under 99.1. If you could clarify that.
You see, I've quoted authorities that where you will talk about concurrent jurisdictions. So the Supreme Court has a jurisdiction to interpret the matter of the Constitution. And the High Court has to look at issues of the vacancy of seats. The authority is very clear that the sheer fact that the High Court has jurisdiction to look at the vacancy of seats will not oust. The word is oust the jurisdiction of the Supreme Court to interpret a constitutional matter. And let me tell you the constitutional matter here. The constitutional matter, which is very critical and is lost on most people, that can a Speaker of Parliament assume the role of the Supreme Court and interpret a constitutional provision relating to the vacancy of seat? This is what they don't want to address.
No, but Honorable, I thought the Speaker read the Constitution and was applying it per his understanding, right? So because first of all, you have to read the provision, understand it more or less, interpret it in a way that in how you understand it before you can enforce it. That is in the absence of a rival meaning. But the point, I think, is that at the time the Speaker was making the declaration, he said he had not been served with Afenyomakin's process, even though he had heard of it. So I think that point must be made clear.
Yes. When he said he's heard about a matter pending before the Supreme Court, with the greatest of respect, that statement alone should make him law-abiding and say that, can I have it before I proceed? So the Speaker himself is conceding that he's aware of matters pending before the Supreme Court, but it's not been served. Nevertheless, I will not look at the processes in the Supreme Court and go ahead and pronounce judicially matters preserved for constitutional interpretation by the Supreme Court. That leaves much to be desired.
The other point that Beatrice raises is the fact that you did not seek any declaration in respect of the Amefi Central MP, but you sought to, couch an issue around it. Was it deliberate or it was an oversight when you were putting your original process together?
Look, the original process dealt with the three MPs without the Amefi MP matter. But then when Thaddeus Sorry wanted to bring all that the Speaker wanted the Supreme Court to know, it was made part of it. Are you saying that the Supreme Court should ignore the processes before it and pretend that it doesn't exist? But what is the nature of that too? If the three will affect the Amefi situation, what is wrong with that? Ignore the Amefi case. If you ignore the Amefi case, and even if they imported it, would it clothe the Speaker with jurisdiction to declare vacancy of seat, even on the authority of what Tanko wrote and what Ivy Johnson wrote? They said it is the High Court that has the power to do so. So the Speaker, on every permutation, was totally wrong. And let my colleague, who is close to you,
it's actually called Beatrice.
Beatrice, you need to concede that the dissenting views that you are holding on to, I could see how religious you are in trying to enjoy the dissenting view. The dissenting view damns the attitude of the Speaker. The very dissenting views that you are trying to uphold, and you are wearing like a necklace, it damns it. They are telling you that it is not the Speaker who has the power to declare vacancy, but rather the High Court. So what is the point of the matter?
I see. Just conclude. Justice Shamsrai, welcome to the program. Give me a minute. I'll come to you to hear what you think about it.
I think that Honorable Atasia is so confused about the whole matter. We are saying that
he's confused about a matter he took to court as lawyer.
Yes, about the whole matter. Because you see, it is in his interest to mix up all the issues to confuse our viewers. Because we are saying that even before you come to the determination of whether or not the Speaker's Act was constitutional or not, whether or not the Speaker did what he was not in law allowed to do or barred in law from doing, before you come to that determination, you must first determine whether the court has the jurisdiction. In fact, the reason why all of us celebrate the case of Marbury and Madison was because they had a similar instance. Whether or not the right of Mr. Marbury had been breached, the court said, yes, your right has been breached. Whether or not you have a remedy at law, the court said, yes, you have a remedy at law. And however sad your situation is, you have come to the wrong court because the Constitution does not clothe us with the jurisdiction. So Mr. Atasia should first not even talk about the merit. We are on the jurisdiction. When we settle the matter of the jurisdiction, we will now come to the merit of the case. And what are we saying? We are saying that the assertion that because the Supreme Court has exclusive jurisdiction to interpret the Constitution does not mean that they have jurisdiction to declare or determine whether a seat in Parliament is vacant or otherwise, even if it were clothed as a constitutional matter, and that at best what they have is a reference jurisdiction and not original jurisdiction. I think that this point has to be made clear. And I'm saying that the Supreme Court, knowing that they did not have original jurisdiction in this matter, before they could determine, quickly went to hide under the conduct of the Speaker, which conduct the plaintiff had not complained about, because at the time of invoking the original jurisdiction, that breach had not occurred. So you cannot come under Article 2.1 and say that if a person alleges that an act or omission of any person is inconsistent with, so here they are alleging that the act of the Speaker, and that's what Mr. Thatcher is complaining about, that the act of the Speaker, who is a person, is in contravention of the Constitution. But at the time the writ was filed,
the act had been taken place.
So what is the Supreme Court declaring? Then let me also make this point, that there is no way you can determine whether a seat has become vacant or otherwise without going into the factual matters, because whether or not a seat of a member of Parliament is vacant, it's a matter of fact and not a matter of law. And so you cannot just say that that is a purely legal issue. You cannot determine that without looking at the constitution of the party. You cannot determine that without looking at overt and covert acts which occurred. And before I conclude, Selorm, let me say that the Supreme Court themselves, in page 35, when they were concluding, the last paragraph, knowing that this decision cannot stand the test of time, made a certain conclusion. Look at what Asaridaku said. In the end, we reiterate that on the true and proper interpretation of Article 91G, only requires that 1, an MP must vacate their seat. What is the determination that the MP has vacated their seat? 2, if they leave the party under which they were elected, how do you determine whether or not they have left the party under which they were elected, or join another party or become independent and seek to remain in Parliament under their new political status? The first question I want to ask is whether Mr. Thatcher and all other MPs are able to tell us whether Madam Cynthia Morrison and the Suhum MP wants to conduct business with the MPP side. Are they able to tell us that today as we sit? So are they able to tell that they want to conduct a business with the MPP, or they want to remain independent in this 8th Parliament?
The point is that their quest to be independent is in the next Parliament, not in this Parliament. But
that's what I'm saying.
Yeah,
that
so
for now,
hang in there. Honorable Thatcher, I want to bring in Stremshire, but you deal with, for me also, the matter of the concurrent jurisdiction.
Yes,
so, Honorable,
that's another matter.
Dr. Justice, Honorable, let me bring in Stremshire. Justice Stremshire, welcome to the program. I understand your movement difficulties, but I hope we do justice to this, as your name is. So, before we start, can you clarify for us why the Speaker did not make a representation on the Monday 11th and also on the 12th, and whether or not the Speaker, or actually why the Speaker did not cause a statement of case to be filed for him? You were part of his legal team.
Yeah, what I would say is that those are matters of lawyer-client, relationship, which I'm unable to disclose at this place, so we can put that aside.
Okay. All right. So, what does the Speaker think about the decision? Have you engaged him since? What do you think as lawyers for the Speaker?
Again, that is a client's lawyer, privilege.
Okay. So, you as a lawyer, if somebody who was in the matter, what's your initial impression about the decision as rendered by the court?
Well, I think the first point which we have all been talking about is the jurisdictional issue, and I have followed the conversation. You see, it is true, and we all agree that the Supreme Court has exclusive jurisdiction to interpret the Constitution. What seems to be the question now is, how does the Supreme Court exercise that jurisdiction? This takes us to a very fundamental issue. When you read Article 30, there are 2 types of jurisdiction for the Supreme Court when it comes to interpretation. So let's look at it this way. Let's create an umbrella here. The Supreme Court has exclusive...
Article 130, you mean?
130.
Yeah, it tells us that the Supreme Court has exclusive jurisdiction to interpret the Constitution. That's the first point. Within 130, we have two branches of interpretation jurisdiction. The first one is original, and the second one is reference. So saying that the Supreme Court has exclusive original jurisdiction does not really resolve the jurisdictional issue here. It means that we have to go further to find out, is this a question that the Supreme Court will interpret by way of original writ or by way of a reference? So the first point I want to make is that in as much as we all agree that when there is an interpretation issue, the Supreme Court is the only authority to interpret the Constitution among the courts, we are divided on the question whether that jurisdiction will be exercised originally by a writ or by a reference from the High Court. I think that's where the division is. Now, my point is this. We have been making a general, error in saying that once the Supreme Court has jurisdiction to interpret the Constitution, then no matter how it happens, it has to. But that is not what the authorities tell us. The authorities have told us from way back in 1970, when the Bedema was decided, through Edusei, Gage, Mensah, and all the other cases, that there are situations where the Constitution carves out a part of the enforcement of the Constitution to other courts. One of such situations is when there is a human rights issue, you go to the High Court as original jurisdiction. Another is when there is an election petition, you go to the High Court for election petition. In all the cases where the Supreme Court decided that you can come to the Supreme Court to challenge a person's membership of Parliament, are situations where there is a violation beyond the electoral practice. There's a violation of the Constitution itself. So the fact that some cases on questions of challenging the election of a member of Parliament, which originally is reserved for the High Court, the fact that such questions have been decided by the Supreme Court, there's a principle. If you read the cases, it is only when the Supreme Court comes to the conclusion that the continuing sitting of the person in Parliament is a violation of the Constitution itself, and those ones come under eligibility, criteria, whether the person is a dual citizen, whether the person is a member of a particular constituency, and all that. Those were cases that were decided on that. So we should not confuse the situation of the fact that there's an interpretation question, then therefore we have to go to the Supreme Court. No, it doesn't work that way. Let me tell you, when interpretation itself is not a substantive jurisdiction, a court must first have a jurisdiction to enforce the law. It is when the court is about to enforce the law and there's a question of interpretation, then the court will do the interpretation. So no one actually goes to court, because the common law tradition, no one goes to court to just ask a question whether or not this is true and then goes back home. It is not allowed. That is what we call advisory opinion or a declarative judgment. And in the common law, that is not allowed. And in our Constitution in particular, the Supreme Court has said over and over again that we are not a dictionary. You don't just come to us and ask the question, what is the meaning of this? And then you get the answer and you go home. No. You must show us that we need to give you a specific relief. And if you read all the cases that have passed, there is nowhere that the Supreme Court will just give a declaration and then goes to sleep. It goes on, and that is because when you read Article 2.2, 2.1 says that the Supreme Court has the power to enforce the Constitution, and then when someone alleges that. Then when it comes to 2, it says, the Supreme Court shall, based on the declaration made, shall make orders and directions. So the Supreme Court doesn't have the jurisdiction to just give an opinion as to what the meaning of a law is and then leave it there. That is the first error which you can see from this decision, that the court basically just said, this is the meaning of Article 97 and gave no orders. But Article 2.2, Selorm, if you have it before you, you can
Article 2.2 says the Supreme Court shall, for the purposes of declaration under Clause 1 of this article, make such orders and give such directions as it may consider appropriate for giving effect or enabling effect to be given to the declaration so made.
Precisely. So based on this, the Supreme Court has always said in a series of cases, and I did some article where I have pointed out some of these pronouncements, that it cannot just make a declaration at the Clause 1 without giving a direction under Clause 2. So when the court seemed to have made a declaration under Clause 1 without any order under 2, that itself is a question which we have to explain to ourselves why that happened. It appears that then the court has given a decision. I mean, it has just interpreted the constitution and has left the parties to go and do whatever they like with it, which is exactly what the Supreme Court doesn't have the power to do as per the previous authorities. Now again, let's come to the issue of the High Court. I think there's also another mistake which we have been making when it comes to Article 99. You see, 99 did not say that the Supreme Court, the High Court, shall declare the seat vacant. No, that is not what is there. It simply says that it shall have the power to determine the question whether a seat of a member of parliament has become vacant. If you have 99, you can read it for all of us to see, to understand. It did not say that the High Court has the power to declare. No, it says that it will determine the question. And in law, when we say a question, we are not just asking question or no. We mean a question which is before a court. So what it means is that there should have been an issue which should have been taken to court, and the High Court will determine the issue. But a lot of us have been reading that provision, and we assume we have been replacing determine with the question of what declare. And then based on that, we have concluded that because the High Court is to declare, the Speaker doesn't have the power to declare. There are about 10,000 people who apply the Constitution every day. That is public officials who apply the Constitution every day. And when they apply the Constitution wrongly, what we know is that you can go to court and then raise a question as to whether they apply the Constitution rightly. But to say that when it comes to the Speaker alone, and there's a question of there's a situation of vacancy, the Speaker should wait, or the Speaker himself should go to court and seek a decree of vacancy before he can declare, the seat vacant, is to bring an interpretation which will lead to absurdity.
But Justice, I think the point also is that once the Speaker got wind of the fact that there is a challenge to the interpretation he was intending to put on the matter, he should have waited to see the outcome of that, that question that Afenyo-Markin was asking the Supreme Court in respect of the interpretation of 97(1) G and H. But he went ahead to make his decision or declaration, however you may want to call it, without waiting for the Supreme Court, when he knew that there was a rival meaning put on the same provision and the Supreme Court had been called into the matter.
Some people find it very convenient to say that the Speaker should disrespect the Constitution and the Supreme Court. And that's their own thinking.
No, Natasha, let Justice
Am I the one to speak?
Natasha, let Justice Shamsha answer my question. Yeah, so it's to you, Shamsha. Natasha, I'll come to you. I'll give you enough time, sir. So Justice, go ahead.
So two things. Put yourself this way: if you are exercising your official powers, your powers under the Constitution, okay, and you are told that someone has a different view from what you have, would you wait for the person to go to court and get before you do your work? That is the first question. I think many people agree that the fact that someone disagrees with your exercise of an official power does not necessarily mean that you have to stop. Okay, that is the first point.
But the person had gone to court already. The person had gone to court prior to the declaration or the comment.
That is what I'm coming to. That is what I'm coming to. I think the Speaker has made that point very clear, which was one of the reasons why there was a motion to set aside the order, which was made, which was why we were in court, I think, 3 weeks ago. And that point was simply that the process itself, the process upon which the order was made, was not served on the Speaker. And you and I will agree, and I think everyone who is a part of this conversation, all of us here will agree that the fact that you have heard of something, service is very essential. That is why even when you have served me and I've received it, and the service is wrong, the same person who received the service and I've read it, I can go to court and set it aside. Why? Because having information about something is not the same as being properly served. And I think Senior Atacha will agree with me that there have been so many instances where he has gone to court to set aside service on him, not because his client didn't know, but because he thinks that the method
Counsel, it will be dubious for anybody to say, even where he's seated at that high pedestal, that I am aware of matters pending before the Supreme Court that will impinge on what I'm doing here. Nevertheless, I'll go ahead. It will be. I
think we need to. See, that is exactly what I was trying to explain.
I get the interest, but let Justice Wright finish. And then I'll come to you.
It is unfortunate that we don't want to accept some of these basic things that we all do in court. There have been so many instances, Selorm, and you would agree that the fact that your client has received a notice, even when he has been served. And we have all been victims or perpetrators of this every day in the courts. Where your client has been served, you have received it, but the law allows you, even after judgment has been given, to set aside the service merely because it has not been properly served on you. And that is a settled principle of law. As to whether you believe that the speaker is entitled to that right to also set aside services or to question the way and manner in which it was served, that is another matter. But the position of the law on this matter is very settled and clear. So, Selorm, my point is this.
But Counsel, are you aware that while I was on my feet, I brought it to the attention of the speaker that they want you to commit contempt of court. So it was not just a matter of he being informed about the process in the Supreme Court, but we even brought it to his attention that you are being set up to commit contempt of court.
But he hadn't been served. I also know. But he hadn't been served. Is that correct? He hadn't been served. Honorable Atacha.
Yeah, the man has not been served. So how is he going to suffer any? I mean, contempt. What we know is that contempt means
he must be served with the order or with the process or whatever.
You must be aware of the order and what the order asks you to do.
And your disobedience of it must be willful.
Another lawyer, even a senior lawyer, tells you that do this, doesn't mean that you should obey what the senior lawyer is saying. You also have to exercise your discretion as a lawyer to know whether so. And clearly, we know that there couldn't have been a contempt on this matter because the speaker was not served, and so there couldn't have been.
It has come to his knowledge. Go back to Moffat. Counsel, it's not just. The physical service. No, please.
I don't want us to go.
No, guys, you hang in there. Guys, hang in there. This is the big issue. We are on 97. Your microphones are off for now. Let me do my work. Your microphones are off for now. Your microphone is off. This is a big issue. 97.3 City FM. Also live on City on City 97.3 FM and Channel 1 Television. Also on Twitter and on YouTube. We are happy to have your comments. I'll read a couple of them in due course. My guests this morning are the Honorable Samuel Atacha, Member of Parliament for Abuakwa South on the ticket of the MPP, and also was a member of the Afenyo Marking legal team that argued the case. Beatrice Annan is the deputy spokesperson, the John Mahama campaign team, also a lawyer. Dr. Justice Shremsrai, the doctor is important. Dr. Justice Shremsrai is senior lecturer in public law, University of Ghana School of Law, and also a member of the Speaker of Parliament's legal team. Franklin Kujo will join us later, and also Dr. Ezekiel Obing Ajekum will join us later. So we've been trying to look at the Supreme Court decision, the matter of jurisdiction, the matter of whether the Speaker should have made a comment or not. And of course, my guests have taken their positions, and we're trying to cross-pollinate, but that doesn't appear to be happening. Justice Shremsrai is on the floor. Justice, if you can just conclude, so I bring in the others. Yeah, I'll take a break soon, though.
By way of conclusion, the first point is that the fact that the Supreme Court has exclusive jurisdiction to interpret the Constitution doesn't bar another person who is working with the Constitution to also understand the Constitution and apply it. And that has been made clearly in the case of Ni Obichu against the Attorney General, where Justice Duchi made it emphatically clear that the exclusivity is a question among the courts. What it means is that it is only when the issue comes up among the courts that the Supreme Court has the exclusive. It is not when the matter is being discussed in Parliament or any other place or committees or even on the street. Otherwise, then the Constitution will be unworkable. Now, the second point I wish to make is that the High Court does not have a jurisdiction to declare a seat vacant. It has a jurisdiction to determine a question whether the seat has become vacant. And that is what the Constitution says. And that question must be raised in the High Court, not in another place. So if the question is raised in the Supreme Court, on the floor of Parliament, in our homes, that does not qualify as a question within the intendment of that clause. The third point I want to make is that in all this occurrence has strengthened our democracy in so many ways. The first one is that it has tested our institutions. And when I say our institutions, I'm talking of the courts. It has tested Parliament, and it has also tested, the executive. And for now, we have, for the first time in our history, seen a very clear contention between the judiciary, the executive, and the legislature, which is good for our democracy. Secondly, I think the occurrence has also tested the temperament of the persons, the temperament and the character of the persons who control and operate these institutions. And you see, we have seen for probably the first time how the people we hold in very high esteem are just like all of us who can be overwhelmed by issues. We have seen frustration have been expressed from almost all the persons who are involved. And I think it's also a good thing that we can appreciate that when it comes to constitutional matters, when it comes to institutional matters, it can also be very personal. And we saw that in the previous days that passed. And finally, it has also tested we, the citizens, as to whether we are people of integrity, whether we can stand by principles and stand by them and make sure that they happen. So, for example, we have seen people who in the days past were in support of something, and when it comes back and they take a different position. And these are all things that we have learned over the past 3 weeks. And I think in all, we have all benefited from the exercise, and it has strengthened our democratic institution and ourselves. We hope that the decisions that have been made will be one that will be something that we can rely on in the future. Now, when it comes to law, I think what has happened has also made it very difficult for us to have what we call clarity in our law. The reason why law is very important is that law ensures certainty, predictability, you see. So whenever we have a situation where it is becoming difficult for us to predict what will happen, the consequence can be very serious. So imagine someone we have been fighting to get foreign direct investments and all that. Someone carrying billions of dollars to Ghana. One of the first things investors do when they come to the country is to speak to lawyers. What happens when this and this happen? Would I lose my investment or not? And we lawyers sit in our offices based on the decisions of the courts. We give advice. And the common law lawyers' advice is a prediction based on things that have happened in the past. Now, what you and I and all of us in this studio can agree to is that it has become very difficult for us to predict what point in time the Supreme Court has a jurisdiction over a matter and what point in time it doesn't, when to go to the High Court or when not to go to the High Court. While we lawyers banter over this in courts, on even on this TV station and everything, the real effect is that investors are getting confused and may not be very confident in bringing their monies and their resources to the country. And this is why I think that we should be like the English courts. One of the reasons why the Industrial Revolution was successful in England was also because of their judicial system, the predictability, the common law being a court based on judicial precedent. So if we are not striving to ensure that we keep to our precedents and we don't keep to them and we change them as and when, one of the indirect consequences is that we are depriving our beloved country resources and investment that will make us a prosperous nation. Thank you very much. Selorm.
All right, thanks.
Yes.
Thanks, Justice Stromstry. But I guess you're hanging on for a while.
I'll be on for a while.
Yes.
Sure.
Let me. Yeah,
so address some of the things. I'll come to Beatrice. We'll take a short break and come back and deal with other matters in respect of this.
Okay. I'll be very brief.
Okay.
I'm glad that we have a lecturer with us. I do not know what certainty means when you go to a court of competent jurisdiction and then you have 5-2. He knows what it means. That is certainty. That's the decision of the Supreme Court. So certainty should not be lost on us at all.
If I may, since this one is directed at me.
My brother.
No, I thought you had finished your point. So, I mean, you could note the point down so that when you get the opportunity next time, you deal with it, yes.
So I don't know what certainty means. If certainty is at the whims and caprices of a syndicator, then it's for them to go ahead.
I wonder why you keep bringing a syndicator. One, he's not a lawyer. Two, he's not in the matter. He's not come up anywhere.
To be the Chief Justice.
No, I'm not sure. He doesn't even qualify. He's not a lawyer.
That is why they'll be comfortable with the judiciary.
I'm not sure about that. I don't know about that.
Okay, let me abandon that. Now, my colleague said something which I find very, very interesting. my colleague is very subtle and is playing semantics. He says, when you come to Article 99, if you look at the marginal notes, the determination of the membership. You see, how can you determine?
I did not say you should look at the marginal notes.
When you come, no, I'm saying so. I'm saying look at the marginal note determination. How do you determine something when you don't come out with a position? The position that you come to is a declaration. So when you read, the High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a member of Parliament or the seat of a member of Parliament has become vacant. At the end of that determination of the question, you make a pronouncement. I hereby declare that your position has been, declared vacant. So, I was very surprised that we were doing this semantics. They had joined. How do you determine a question without you coming out with a position? The position you come to is necessarily your declaration. I'll leave it at that. Now, let me come to a point that I'm so glad that I have a lecturer here. You see, when you pay regard to what has happened, I was surprised to read at page 12 that there has been a precedent.
At page 12 of what? Of the decision?
Of the decision. If you look at Michael Ankuma Nimfa, if you look at New Patriotic Party and others.
The next party is Senator Rawlings.
Senator Rawlings. Look, it is obvious that you have a situation in which the High Court and the Supreme Court may have concurrent jurisdiction. But do you know what the Supreme Court said? The Supreme Court said, in the event of that, and we need to interpret the Constitution, our jurisdiction is not ousted by the mere fact that the High Court can do that. I don't know why people want to run away from the settled decision and they're now talking about the fact that it is the High Court that has exclusive jurisdiction. And I've made the point very strong that exclusivity of the High Court to determine seats vacant is the invention of some people. The word exclusive is not there. It is only when you go to Article 130 that you have the word exclusive. So please, if you make a declaration without orders, anybody who is affected by the declaration can go for the orders. You know that by now. And let me tell you, the declaration without the orders will not make the declaration impotent. He knows that by now. This is the one educating a lot of people to come to terms with the law. So, excuse me to say, if it was an omission, it will not detract from the fact that the declaration has consequences. And anybody who is affected by this can go to court, or even the plaintiff. And I'm saying democracy has won. The one who went to court can go to the court. And it's not late to say that, please, this is your decision. More so, when the decision was not read spontaneously, at the time that it was said that it is 5-2, and that the reasons will come later. So now that you have seen the reasons without the orders, counsel and lecturer at law, you can always go back to the Supreme Court and say that, can you give teeth to the declaration? And if somebody should disobey the express orders, as Justice Atungba has said, that person stands the opportunity of going to jail for 10 years. These are all provisions in the Constitution. So this is what I want to add to what the lecturer has said.
Very well. So Beatrice, just conclude on this, and then when we come back from the break, we'll now deal with the consequences of all of this, what it means for everybody. Okay. Yes.
Selorm.
Justice.
You said I was going to be given the chance to
yes, but I didn't put a specific time to read. Beatrice has been quiet for some time, so let her flow. I'll come to you.
All right.
So first of all, Honorable attaches fixation on the fact that if anybody disobeys the orders of the Supreme Court, the person will be liable. Where are the orders of the Supreme Court in this 109-page judgment? Can somebody, he cannot tell us what orders the Supreme Court made. The Supreme Court only granted the reliefs as formulated by the plaintiffs. There were no consequential orders. And that's exactly what Justice Sai was talking about. That to the extent that you did not give consequential orders on how these provisions should be complied with, the fixation on if anybody disobeys is only for a political, discussion. again, let the point be made that it is true that courts may have concurrent jurisdiction, but in this matter, there was no concurrent jurisdiction. There was no concurrent jurisdiction. The Supreme Court nicely quoted some decisions. First, the ex parte Zinato decision, and came to the Jashiquations case, and then finally landed at in the MPP. In all those matters, what the Supreme Court failed to note was that those matters did not originate from the Supreme Court. All those matters were decided at the High Court. It came to the Supreme Court under very different circumstances before they assumed jurisdiction. So it is not as if, and so, you know, the absurdity in this proposition is that we are being told as practitioners that the Supreme Court may have concurrent jurisdiction with the High Court or any other court in any matter. And so when you are a lawyer and you want to go to court, you may elect whether you should go to the Supreme Court or you should go to the High Court. That is the absurdity. But even by the rules of interpretation, Selorm, let me take you to Article 99.2. Article 99.2 says that a person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal. So let's note this. You also know that the Supreme Court has appellate jurisdiction in all matters. Is that not so? But we were in this country where the Supreme Court, in a long line of cases, have told us that when it comes to the issues of election petition or matters relating to Article 99, the right of an applicant or a petitioner ends at the Court of Appeal when it comes to matters of appeal. And that if the court or if the framers of the Constitution intended that the appeal should end at the Supreme Court, they would have stated so. And so Article 99.2 places a limitation on the Supreme Court to hear matters of appeal when it comes to election petition or a determination on a vacancy when it comes to a seat. Even though the Supreme Court has the jurisdiction on all matters of appeal. Why? Because this is a special provision. And we know that by rules of interpretation, where there is a general provision and there is a special provision, the special provision overrides the general. And so, yes, the Constitution may give or have given the Supreme Court original jurisdiction when it comes to interpreting the provisions of the Constitution. But you see, that jurisdiction itself was not thrown at the Supreme Court as if they were tomatoes. The framers of the Constitution knew that there will come a time when people will just go to the Supreme Court for opinions or to satisfy their political inclination. In fact, we have a precedent in the case of Bilson versus AG. Mr. Bilson had gone to court on the basis of the 1992 Constitution, that by reason of the transitional provisions in the Constitution, they may not get a remedy if people had complained about excesses of the military era. The court said that we are not here to offer advice, that the act must occur. So here, if the Supreme Court even had, I've established that they did not even have concurrent jurisdiction, because one says that when it comes to matters that deals with vacation, and the other is just a general interpretation. So let me ask you, assuming the parties went to the High Court for a determination on a vacancy, and the parties did not place rivalry meaning on what the true and proper interpretation of Article 97 1G and H were, would we have invoked the jurisdiction of the Supreme Court? No,
the High Court would have dealt with it.
Yes.
But in this case, there's a rival meaning. Somebody says that the meaning that the speaker is seeking to place on it.
And that is what brings me to the...
Rivals another meaning.
You see, that is
and by ex parte acosa, when that happens, you go to the Supreme Court, and the Supreme Court interprets the matter.
Where should they have placed the rival meaning? In ex parte acosa. That when the matter arises or in the course of litigation.
So in this case, the matter hasn't arisen.
Where is it?
So there was no forum where the matter has arisen.
So you see, and this is what, the judges embarrass themselves so much. Look at page 35. I hope it's page 35. Let me see.
So what are you looking for?
Which is page 37. And look at the conclusion. And look at 1, which has to do with the majority opinion. It says that an order declaring the interpretation placed on Article 91G and H as inconsistent with the true meaning and import of which order declaring which interpretation placed. In the matter before the Supreme Court, which interpretation was placed? Because before Asare Darko himself started, he said that the position of the Attorney General aligns with that of the plaintiff in this matter. And again said that the Speaker did not file the submissions to this matter. So when you say that an order declaring that the interpretation placed, who placed what interpretation? It's inconsistent. And which of the interpretations are you complaining about? This is the absurdity we are talking about. So you cannot hide under concurrent jurisdiction to say that I've assumed jurisdiction. First of all, there is a special provision that derogates from your original jurisdiction. It ought to have been a reference jurisdiction. And then they copiously took solace in ex parte zinato. I think with all deference of the Supreme Court, in the ex parte zinato, the matter was before the High Court. Gary had disguised what was a matter of an election petition, and in the release has stated that on the true and proper interpretation of Article 94, 1D or so. Then Zenato's lawyers raised an issue that to the extent that the release being sought is a declaration that on the true and proper interpretation, then the matter fell within the purview. And this is what happened. The High Court Justice Akabuafo, overruled that application that it raises a constitutional issue. Then they went to court to quash the decision of Akabuafo. So the court granted the certiorari right, quashing the decision.
Making them refer the matter to the Supreme Court.
And said that we will interpret the constitutional provision because we know it will come back to us. So when we finish, go back to the High Court and apply it. That is what we are saying. That the Supreme Court cannot in themselves assume original jurisdiction in a matter that you have reference jurisdiction, because in your own conclusion you said that for your interpretation to have the full, or for people to apply it well, you set out parameters that the person must leave the party, that the person must vacate the seat, the person must join another party or seek to remain in power. How are these matters, how are they to be determined? So when the Speaker goes, we go back again, and the Speaker says that by this Supreme Court decision, I am making a determination that the person must leave their party by the Supreme Court decision. So if you take the party of the MPP, I'm relying on their constitution that says that you automatically forfeit your membership if you contest on the ticket of independent. What would the Supreme Court then be saying again?
Interesting. Of course, so many questions
very
to answer.
Absurd,
I've not said absurd. I said interesting. I mean, interesting from all three.
Yeah, you can only be correct about it.
All three panelists. This is a big issue. I'll take a short break. When I return, we will look at the consequences of this. In fact, the MPP constitution says one thing, based on which Speaker Michael Quay in the last parliament took a decision. What happens to this provision in the MPP constitution, which says that if you declare your intention or pick up a form to contest as an independent candidate, you forfeit your membership automatically? What does that mean? Does it mean that the decision of the court now makes that provision unconstitutional and null and void? What does it mean? There's been an issue also raised about empaneling of the judges. Of course, empaneling judges is an administrative duty of the Chief Justice. Of course, people have argued in a long line of cases that that is a very tricky one, because the Chief Justice, knowing the direction he or she wants to take with a matter, will empanel people who think like him or her, and that decision will produce the outcome the Chief Justice wants. Should we begin looking at that administrative role about empaneling judges, which is being given to the Chief Justice. We'll look at all of that when we return. This is The Big Issue, 97.3 FM, also on Channel 1 television. Don't go away.
Dr. Baumia once said in a church,
since 2014 in India, they have a policy to only build concrete roads because it works out much cheaper. So I said, well, let me bring this to my bosses, and we have been discussing this as recently as last week in Parliament. And Bishop Dag, I'll let you into it. Cabinet did decide last week that we should move towards concrete roads as a country.
Where are the concrete roads? It was all lies. You trust this man at your own peril. Vote John Dramani Mahama for president. Trustworthy, honest, and reliable. Vote for change. Choose the umbrella. Vote John Dramani Mahama and the NDC.
How far with your internship?
To be honest, I'm so nervous about starting this new role on Monday.
Oh, please. I know you'll be great at it. You should be worried about what benefits they have. Example, do they have health insurance?
I doubt they will have that for interns. But no shaking. I have NHIS already.
After you on a line, ting.
Ina, look at you. What are you going to do in the office when you can just download their app to register for an NHIS membership?
Yes, my people. You heard right. You can now download and register your membership on my NHIS app. No long queues or tedious paperwork. All you need is your Ghana card to register for yourself and for others. Once you register, you get a new digital NHIS card on your phone. My NHIS app gives you access to credentialed health facilities and services across the country. NHIS covers over 95% of disease conditions in Ghana. Access to healthcare just got easier.
Now let me sign up quickly. Miss Seth, I'm starting next month.
John, mema wakwaba.
Yeah.
Alaji, mema wakwaba.
Yeah.
John, I had a bro, one on them.
I really am a Ghana and Menamo, and America can be Jano. Tono and Tina Saba.
Alaji, I had a bro.
Yo, Medasi. Moamonim, Tamana, Amawa, which you Momiana, and a Bobo and a Kakra. As I say, dear, my crowd said, me person me bewareno. Namiko CSL. Name man sign Jan and Nasubium, no your crabeshe.
Yo, I was not for, yes, Empire. Yo, I'm a Ghana. What's wrong?
Mean to me, ain't son, your bread baby, I would have a fair way. A man who be meant to me, beauty. Forward ever, backwards. Never.
John, what Okoya would me very fast. I would say a come, do so. Trap me none on me. Yeah, 3 years such as here by come on your school uncle. And I say, yeah, on my essay.
I say, oh, my sister, I'm be sure, boy. Sahu machi, 2 o'clock okra. Meko band, the Makwa Iska, Eddie Abraham Ghana, Nama Bonigetri, I'm an starting coconut. Hey!
Akunta, you are still incompetent.
2 persons are in Mamia Bravo, and 2 chachati aviator. There be Emma so.
Alaji has also promised us jobs through digitalization. A Jumambe Busse.
Alaji, dear, Metanasua, Nema sorry. Emri Bia Mecania Besano. Which me talk an ear, light when you phone so, and mammy, baby, our name be yo, I'm a Ghana, and ya men me worry amount. Alajini, Jonesuni, where choose you.
No Ababa said. Alaji, number 1.
Alaji number one.
Esuro.
You're welcome back. This is a big issue. My guest this morning, the Honorable Samuel Atacha, Abawka South MP and member of the Afenyimakin legal team, Beatrice Annan, deputy spokesperson, the John Mahama campaign team, a private legal practitioner as well. Only that I'm not sure if she will go back to the court.
I will go. In fact, I'm going back.
Dr. Justice Chansrai is a senior lecturer in public law, University of Ghana School of Law, and is a member of the Speaker's legal team. Dr. Ezekiel Obin Ajekum is joining us now, MPP Manifesto Health Committee member, and Franklin Kujo, President in Money Africa. He will join us soon. Yeah, so we've been looking at the matter of the Supreme Court decision. We've delved into the details of it. Want to now look at what this means. Honorable Atacha, you are in Parliament.
Selorm.
Yes.
I think you're undertaking that.
Okay, so I promised you. So you wanted to make a quick intervention. I promised you.
Yeah.
Justice Chansrai, yes.
So, on two things. The argument has been made that the High Court has a concurrent jurisdiction with the Supreme Court when it comes to this matter. I hold the view that the jurisdiction is not concurrent, but even if it is, the Supreme Court itself has a practice direction which it gave way back in 1980, which practice direction has still been enforced in recent cases by the Supreme Court. And the practice direction is for practice direction 1981. If you look at the 1981 Ghana Law Report, it is produced there. And this is the wording of paragraph 6, and I'll read. It is also to be noted that where a cause or matter can be determined by a superior court other than the Supreme Court, the jurisdiction of the lower court shall first be invoked. The Supreme Court may dismiss any such cause or matter with punitive costs to be paid personally by the counsel or the party responsible for bringing such a cause or matter to the Supreme Court in the first instance. So what I'm saying is that even where you argue that the jurisdiction is concurrent, the settled position of the law is that the person shall invoke the lower court's jurisdiction first, and the matter shall come by way of appeal to the Supreme Court. And that is why it is not a proper, application of the law, or let's say it is a very interesting departure from what the settled position of the law, to say that simply because the jurisdiction is concurrent, then it means that you can choose, you can elect wherever you want to go. It doesn't work that way. And that is what I mean by consistency when I said predictability or certainty, which my very good learned senior, will try to, predictability means that we should do things as we used to do it, unless we have good reason to depart. And when we want to depart, we need to address and explain why we are departing by stating the mischief and what we are departing to cure. So the law should not create a situation where we can just pick and choose without predictability. That's what I meant by certainty. And also, for the last issue I have been wondering why the cases of Zanato Rawlings and Kuma Nimfa are being used as though they support the position of the Supreme Court, the majority position of the Supreme Court. Those cases actually tell us that when a court has original jurisdiction, a court other than the Supreme Court, we should go to that court first, in line with the practice direction. And while in that court, when a question of interpretation arises, then that court will refer the sole question of interpretation to the Supreme Court to interpret. And when the Supreme Court is done with the interpretation, it will revert the matter to the court below to apply the meaning the Supreme Court gave in resolving the issue before that court. And that is the meaning of Article 132. So I don't know how Akuma Nimfa and Zanato Rawlings would be used to support the position of the majority. It rather supports the position of the minority, the dissenting opinion, that this is a case we should have started in the High Court. And while in the High Court, if there is any question of interpretation arises, that High Court will refer the question to the Supreme Court. And you see, in all this, I understand why the choice was made in the Supreme Court, because if we went to the High Court, definitely the timelines are not going to favor the plaintiff. So I understand why the plaintiff will gamble and go to the Supreme Court as way of original jurisdiction. But then again, I was expecting that the Supreme Court would be loyal to its position, which has been that even when there is a concurrent jurisdiction, so the positions that is, first of all, the Supreme Court doesn't have exclusive jurisdiction to enforce the Constitution. Other courts have been given as part of the enforcement jurisdiction to enforce. So that's the first point. The second point is that the Supreme Court has exclusive jurisdiction to interpret the Constitution, but that jurisdiction will be invoked either originally by a writ or by what? A reference. And the situation where it will be invoked by a reference was when another court has original jurisdiction over the matter. Then that court will refer the question to the Supreme Court. And where it will be invoked originally is when the Supreme Court has its own, when the Supreme Court has enforcement jurisdiction. So from all this, it tells us that it is the court that has the enforcement jurisdiction that determines the forum, not the question of interpretation. So these are the 2 points that I wish to make before we proceed. And I'll be signing off because, as I told the producer, we
appreciate that.
Lecturer, before you leave,
See, Natasha wants to punch one or two before you leave.
Yeah,
for the road.
Oh, no. It's a good man. I really know what he's saying. You see, before you leave, which forum was it going to be determined that issue raised by the Attorney General, whether or not the declaration by the Speaker of Parliament of 4 vacancies in Parliament is subject to the Supreme Court judicial review powers under the Constitution? Which forum is going to determine
that? Is exactly what 99(1) is saying. That
no.
I thought you asked me a question, so you are allowed to answer the question.
Yes.
That is exactly where the 99(1) comes in. That when the question arises, whether a seat has become vacant, it is that question that should actually go to the High Court, because clearly what the AG is saying is that there is a question as to whether the seat has become vacant. And the 99(1) is specifically on that matter, that when you have a doubt as to whether the seat has become vacant, then you go to the High Court for the High Court to determine that question. And that also presumes that there should have been an event which, one, threatens the declaration of a vacancy, or there should have been an actual vacancy. So where there is the Speaker declares the seat vacant and you disagree, then the question of whether the seat has become vacant arises, then you go to the High Court. Or where you suspect that the Speaker is in the process of determining of declaring the seat vacant, again, the question arises, then you go to the High Court. That is what 99(1) is saying. 99(1) does not create any exclusive jurisdiction or the High Court that before a person vacates a seat, you must go to a High Court and obtain a decree of vacancy before you implement. That is not what 99(1) is saying.
I respect your scholarship, but for once you are reading the law upside down.
Very well, no problem.
Well, so that is understandable because of your where you stand in this matter, being a representative of the.
Very well. Honorable, just a final one on this. You know, the majority opinion took time to talk about the fact that the members of Parliament leaving or vacating their seat will leave their constituents, without an MP. But it did appear to me that, of course, and they did say that the framers of the Constitution did not intend, or did intend an uninterrupted tenure. And I find that quite problematic because when you look at the 97.1 provision, there are instances where the member of Parliament can resign. And the member of Parliament could even die or could be expelled from Parliament for certain stated reasons. Are we saying that should this happen within the last 3 months of the tenure of that Parliament, we would have a problem with the fact that the constituents will not be represented?
You see, we shouldn't fuse the two. So a member of Parliament dies. That is a clear vacancy. And some other scenarios. But we're saying that if somebody said, in the future, I'm going to join NDC, and now I'm MPP, have I vacated my seat? This is the issue.
No. Selorm, there's a correction here to be made.
No, I thought you were gone. I thought you were gone.
I thought the senior wanted me around, so I'm here to...
No, fine.
Yes, yeah. So the provision just simply says that when you leave your party, okay, the provision itself doesn't talk about the future. It is
It does. Linguistic evidence.
Justice, let him land. Let him land. Honorable, go ahead, yes.
So the provision itself is talking
about... Justice, let Honorable, let Samuel Natasha land.
If you analyze what the majority said, they are even saying that the linguistic evidence supports the fact that in the election, you see, and the term of the election is 4 years. So all other intentions which postdate this term, it's what they are trying to address. But in this term, you can't talk about, carpet crossing and the rest of it. Please, we never.
I mean, you see,
if I may respond.
No, just let me put through a question. You know, look at 97(1)H, for example. Look at how clear the language is, and applying the ordinary meaning. Look at it.
Yeah.
A member of parliament shall vacate his seat in parliament if he was elected a member of parliament as an independent candidate and joins a political party. And in the case of the Honorable Isiama, how does one become a candidate of a political party? You first of all must join that political party. And I'm sure his form submitted to the EC, and you have done so many times as many times member of parliament. You submit a form, and I'm sure there's a part of the form that talks about your party affiliation. Or in fact,
precisely.
And so in this case, are we treating Isiama as a member of the MPP, or we are just looking at him as an independent person? Because by submitting the forms, he is now a member of the MPP. And by virtue of your own party constitution, he is a member of the party.
You see, there is a process that will kick in to determine how you become a member of the 9th Parliament. But that will not detract from the fact that currently the position doesn't change. How is it going to be? Listen, let's see the absurdity of this argument. How is it going to be a member of the 9th Parliament if he doesn't initiate processes now?
Yeah, Honorable, let me just answer that. He could resign, go sit at home, and then pick forms if he believes in himself so much, and go and do. We saw it. It happened with Isiama, even though in his own he was pushed out. But he went to sit at home, he filed and did what he had to do, campaigned very hard, and he won.
Yes, the Supreme Court doesn't believe in that there should be a vacuum.
But that is the question we are asking. You see,
because
we cannot cite the Supreme Court's decision to support it, because that is the decision we are even questioning.
Because that's a decision being discussed.
You have not set aside the Supreme Court decision.
No, it doesn't mean. I think that the point we are making is that this is a decision, quote unquote, under attack. That is the decision we are discussing now. Yes. So you cannot use the same decision you are questioning now. So you go to the Constitution. You look at the ordinary meaning of the provision, and that appears quite clear.
No, but if the Supreme Court case has no consequence, then we have become the Supreme Court.
We are not saying it has no consequence. In fact, the question that
it's binding on us, so that your interpretation might be scholarly, but it won't detract from the fact that this is what the Supreme Court is saying. And it's binding.
I don't think the conversation is to say that we are overriding or we are overturning the Supreme Court's decision. What we are simply doing is to put the Supreme Court decision under criticism, and we are critiquing it. So the point we are making is that which we are critiquing cannot be now cited as authority to justify the point. Otherwise,
what can be quoted to satisfy
reasoning if you proceed that way? Now, what we are saying is that when you read the provision, the only reason why this provision is becoming so much complicated is because we are talking of the 9th Parliament, future Parliament, and I think the framers of the Constitution have they don't, because you may not even win the election. So I don't see why they will even legislate to talk about the future Parliament. The law is on the current situation. When you change your vehicle, you must go back to wherever, and then if you want to, in fact, and the only reason why we are even having this is because the Constitution doesn't allow a by-election.
Yes. If a by-election was allowed, I'm not sure it would have been here. Exactly the point.
This issue would not have a reason in the first place. You know, it would have been just so simple and clear that, well, you have cross-cap and you've changed your party, so go back and contest. There would have been a by-election. So the reason why this matter is becoming complicated, we are talking of the 9th Parliament, is because we are in a period where by-election...
But Justice, what do you make of the argument of the Supreme Court that this point will only apply if it had happened midstream? So, for example,
that is the point we are making. That for example, it means that the Supreme Court itself believes in the argument that when you change your vehicle, you must go for a mandate to continue.
Because it's in the same parliament. So, for example, if it happened in the second year, the decision would have affected the same parliament and not the next parliament. That's the decision of the court.
It affects this parliament. It affects it. The only reason why the effect is not being seen as it is that it affects it in the sense that you have to leave. You have to leave. That is why it affects
you don't have parliament. You don't have to.
All right.
Because now the Supreme Court says you can't.
I just have a few brief or short questions for you. What happens to the provision of your party constitution, which says that if you do anything like what these guys have done, you automatically forfeit your membership of the party. So as we speak, Cynthia Morrison and co, are they members of your party? Because obviously they'll be campaigning against the party's candidates in their constituencies. And that new political parties have called anti-party behavior, which carries grave consequences. So what is the status of these persons in your party as we speak? Are they members of your party?
I want to answer this by quoting the Constitution. I'm quoting Article 55(5). The internal organization of a political party shall conform to democratic principles, and its actions and purpose shall not contravene or be inconsistent with this Constitution or any other law. Which is to say that if even the internal constitution of MPP forbids what they have done, you understand, it will never override the Constitution, which says that if mid-term you intend stepping down, then you are out of Parliament. But if you have a future intention, you could activate processes to do so. So that is what it is. And I don't see how anybody can say that. I've said it again. If what MPP has written down as its constitution is sins against the national constitution, it is not a void to the extent of that inconsistency. So this is how we should look at it. If not, we'll go into a lot of problems.
So as we speak, the present decision automatically cancels out provision Article 391 of your constitution, the MPP constitution. Let me read. A member of the party who stands as an independent candidate against officially elected member of the party, or who joins or declares his or her support for another political party or for an independent candidate when the party has sponsored a candidate in a general or by-election, automatically forfeits his or her membership of the party. So as we speak, this present decision now supplants this, and so this is null and void. What then happens to the role of political parties?
You are not addressing the midterm issues. What you are reading?
So this is the provision of your party. Once you declare that you are going independent, and it's against the party's sponsored candidate, it says that you automatically forfeit your membership of the party. And what's your response there?
You don't forfeit your membership of Parliament. That is what
but you are in
whatever
Parliament
you do
on the ticket of the party.
Whatever you do, if you are in the Parliament by the election that brought you, whether independent or MPP, and you want to express a future intention, you do not forfeit your seat in Parliament. Period.
I see. That's interesting. What happens to the whip system then? Can somebody so these guys who are contesting and campaigning against your candidates, are they still on your platforms? Of course, we heard that when the decision was taken, or when the decision was about to be taken, or they went independent, some of them were taken off your WhatsApp pages. You may confirm or not. But what happens? These guys campaigning against your own candidates in those constituencies are still with you in caucus, taking strategic decisions, etc. Is that how it works?
They might even vote against us in Parliament. At plenary, they can.
And you will call them for caucus meetings, discuss strategy, what to do, etc.
Whatever we want to do in Parliament. But please, I want you to come to terms with one basic fact, that no matter anybody will do, you see, if he is in the term of the Parliament that elected him and is misbehaving and even shows intentions of joining another political party, or even he won't work with us again, the Constitution says he will not forfeit his membership of Parliament. So the waywardness of a member of Parliament, you see, in terms of his dealings with the entire tenor party constitution and even the party that elected him, will not detract from the fact that he will still be a member of Parliament.
Very well. So now let's deal with this. Others have said, in fact, former President Mahama has said that he would have appreciated a political solution to this and not a legal one. Now we've gone to the Supreme Court. The Supreme Court has made its declaration. Where do we go from here? I'm not sure whether Parliament could be recalled back given the times we are in. Indeed, your colleagues in the minority, and the minority is so important here because of the numbers, they say, or at least Nilante van der Poel has said that they are not coming back to Parliament. even if Speaker recalls the House, they are not coming because they are running election. They have elections to run, they have elections to lose. They will only come after the election. So where does this leave the so-called government business for which we went to court to get the court to declare Speaker's declaration unconstitutional?
See, those who subscribe to the Constitution and not their political strategy to interrupt the activities of the government will do what they are doing. I cannot believe any member of parliament saying that I will abandon my constitutional obligations as a parliamentarian and attend to other things. It's a waywardness of the highest order.
But representation is part of it. So being in your constituency, dealing with your constituents and appealing to them to give you another chance, all of that is part of the role of the MP. The role is just not in the chamber.
He might choose not to come. But if the Speaker should call us back, those who want to come will come and do business. But it will signal you as one of the persons who believe that, we shouldn't have an appropriation on account so people will be paid.
They say that could happen after the election. Because it's for January, February, March. And that could happen after the election. And why not? Why not?
Because what you are trying to postpone, it can be done now. And it will be done in good time.
And so now the circumstance of the now. In fact, if Speaker, I'm sure you were to be, I don't know your timetable, but I understand that any moment from now, you could be on recess. And the recess comes at this time close to election for a reason. So are you saying that all the business itemized in the last recall, all of that should be done now when you recall Parliament? That would take some time. How about you go finish the business for December 7, come back December 10, whenever, to let's say the end of the year, get that sorted. You can do that till January 6, so that maybe you spare the national kitty the money to recall the House and all of that, and give your colleagues peace of mind to campaign and retain their seats if they so wish. Of course, I know you have done your part, you have paid your dues, and you're not coming back to Parliament.
I think you are just expressing the convenience of NDC. Who would you want to come and business?
No, of course, and I'm putting that to you because that's what Neil Antivanapoi has said.
They've said so, but I'm saying that who sleeps in his constituency, if you like, the rest of the time? The constituency activities can even begin midnight if you are interested. The Parliament could be called, and then 10 o'clock we start. When it's 3 o'clock, 4 o'clock, we've closed. Go to your constituency and continue with the activities.
Even if I'm at Boku or Laura or somewhere.
Well, you should program yourself as to how you do it. That is what it is. And then when there are serious matters to be attended to at plenary, it should take precedence over whatever you think you are doing. And we should bear that in mind. If, for instance, we are talking about a situation in which we need an infusion of about $140 million into the economy, and you say that, okay, let me wait until we finish the elections, and the critical time should lapse. Where do we stand? This country will be deprived of good money so that we do serious matters. The same people who say that the economy is tight, but if there is a window of help and relief for us, and we're saying, let me go to Boku and go and energize the constituency so I get good votes, then people will know where your priority lies. And it's very sad.
So what is the way forward now? It does appear there's some split. I mean, there's some split. Speaker on one side, the
Speaker has traveled.
Yes, but I'm sure he'll come back anytime soon. And so what's the way forward? Are you going to recall or trigger a recall of the House, or you will leave that to Speaker?
Yes, I don't have, excuse me to say, the way forward right here and now, because that should be a leadership decision, trying to get the input from some of us who are, at the lower end of the whole equation. So I don't want you to put me on the spot so that I give a premature, answer, which to all intents and purposes, we need to converge and consult and come out with what works for the nation. I crave your indulgence. If you can spare me the trouble of trying to be the leadership of my party.
Very well. It's been a pleasure. I just want to take your final thoughts on all that we've had. I'll go to Doc and I'll come to Beatrice, and then we'll take a break and come back to deal with the health matter, which I'm sure you are not very interested in. And so there's a doctor in the studio who hold the fort for you very well. So your final concluding thoughts on the Supreme Court decision and all that it means for us.
I want to say that I'm overjoyed that the Supreme Court is upholding the Constitution, and we are in what we call constitutional democracy, but not in parliamentary democracy. The upshot of what they've done is that the Speaker of Parliament cannot become an extension of the Supreme Court, interpreting the law. And even if you go to the dissenting views, it is very apparent that power, if that is what is right, is with the High Court, not with the Speaker. And that, for me, is the joy of what has happened. And guess what? Those who say that the Supreme Court is an extension of the Jubilee House and the rubber stamp what we want. Two men are showing that they can think differently. The Supreme Court is a forum of good people, and we shouldn't say that, oh, the Supreme Court is an extension of the executive. Those who believe in these positions do not understand the rule of law, and it's very subversive of the Constitution to be going that route.
Very well. Thanks so much, Honorable Atasha. Franklin Kujo, I mean, Franklin has come to the party quite late. Franklin is a wounded lion from SAL and all of that. But you've seen the decision. I'll just give you 1 minute to just deal with all you've heard about it, whether I've read it or not, just to conclude.
Well, I mean, I guess it is what it is, really. I mean, this is a country where people are interested in what I call the symbolism of power. And so somehow they want to go for the jugular. Look, whatever happened had already happened. I just wish that nobody, in fact, and I stated last week that it is not my wish that anyone at all, or even once a day in the life of Parliament would not be represented at all. So for me, on that score, I am totally in support of whatever actions were taken, even though I now understand the substantive matters that will be heard. But the real issue really has to do with the way we do our politics in this part of our world. Our politics has become too adversarial, and frankly speaking, I mean, my reading of the judiciary is unfortunately in this particular case, and in a few of the cases, they become like a playground for politicians, and I think it's a disappointment. I hope that they redeem themselves quickly, and the Chief Justice should put the house in order, because frankly speaking, it is not right to have almost 70% of the populace of a country say you are biased. It is just not, it's not fair. It's not pretty, not at all. And I think I'm part of that 70. Maybe I'm top of the 70 right now.
Even if the 70% doesn't understand the issues quite well, because the issues are very legally technical.
That's not true. Look, you make a mistake. You make a mistake and assume that people do not understand what is at stake. You know, that is the comfort of the so-called elite. You guys make a terrible mistake thinking that people do not understand what happens in God. Was it not the same, my good friend, the Minister for Interior, also National Security Minister, who said, well, you keep ruling and be saying people don't have, you keep ruling one side, right? At some point, people will start asking questions. What is it that any time I come here, well, you think Chikata was so stupid that everything Chikata said during the election petition, there was not a single sensible thing he said? That all of a sudden, unanimous, 0. And then put football ground when you play, at least you don't put the crowd and be jet and so forth. Look, it is not pretty. I'm just telling you, 70% of Ghanaians are stupid. To say that the judiciary has become a very harbinger for also the not corrupt, but very biased practices. I know you're an officer of the court, so you are probably worried. I am an activist, and I want to tell you that I think on this particular one, the way they acted, especially in the case of the South, and people watch it. Look, if anybody makes a mistake of if anybody allows themselves to be chucked out of the electoral system, you see, that's where you smell pepper. Like the way we smell pepper. The first one, your docket will be missing. If our docket kept going round until one time a registrar who was doing so well protected a docket. The very day he handed the docket to us, that very day he was transferred to Cape Coast. What is this? So when I talk about judicial chicanery and the kinds of things that some have experienced, I'm like, what? Is this what happens in this part of our world? Apart from the courtroom drama, sometimes these judges be fighting their lawyers. I'm like, hey, what happens here? One time I was in Supreme Court, they were heckling this lawyer, heckling him, sit down, you know. I was like, what is happening here? Say, hey, what high court? I'm going to see from a bull cracker. I mean, what is this joke? So, guys, look, the court is not about criticism. No institution is above criticism in this part of our world. Even the Supreme Court of the United States of America. Scholars write about them, judiciary. We go and read all the Cato papers about the Supreme Court ruling. It is done. I think here our judges have become too mechanistic. Some of them are not bold enough. They are timorous souls, or whatever they call it. They don't want to break from the mold. I mean, how do you tell me that we were even disenfranchised? In fact, the state colluded. The Ministry of Local Government, the government itself, and the Electoral Commission colluded and denied us representation for 4 good years. When we were denied, it was not an attempt to deny. We were actually chucked out of the system before the elections even started. We went to the Supreme Court. This small boy, Attorney General, had the nerve to be disrespecting Chachikata. Some sort of nonsense. And the judges
don't say small boy.
I mean, he's the Attorney General, he's the leader of the bar. So kindly grant him that. Just grant him that. He's the leader of the bar. Yes.
Okay, fine. Listen, it's a small boy. I'm just saying that.
No, he's the leader of the bar.
It's not older than Chikata. This guy had the
no, by the law. It's the law.
He was talking nonsense. But excuse me. And then when the matters were dealt with, this guy, they did all they did. They chucked us out of the system. They said, go to High Court and go and fight your case. We went to the High Court 3 good years, 3.5 years. You know what the judge said to us? No. He has no jurisdiction. And the Supreme Court is sitting there, and I'm hearing them tell me today that, these people who have had MPs who have represented them for nearly 4 good years will be denied representation for just 2 months, and that is the whole world would have to come to a standstill. You think my people don't have blood flowing through them?
Very well. Great. Justice Ramsar, are you there, or you've taken your leave? No, I think Justice Ramsar is gone. It's all right. So Beatrice, you have the final word on this.
I want to say that if you look at the general decision of this court, it shows you that we are not in a good place as a country. The courts are consistently feeding into the perception that they are there to do the bidding of their appointors. And it is the reason why you cannot convince anybody that President Adonoo has been appointing just anybody, including people who are card-bearing NPP members. And I was so embarrassed for Justice Gao.
No, but he's no more a card-bearing. It's no more a card-bearing member.
How do you make that distinction?
No, but he's renounced his membership of the party.
Constitutionalism is that there ought to be limitations to the powers of government, even if the Constitution doesn't expressly say so. What the Supreme Court have done in this decision is to set a bad precedent to tell everybody that the courts are willing and able to assist political parties to achieve their bidding. Look at what happened. That the Attorney General didn't even want the Speaker to have representation. And the court, and it tells you even from the demeanor of the court.
But he did have representation. Stremsrai and...
Yes, and the Attorney General raised the objection and said he had to even represent the Speaker.
But he's Attorney General and he represents the state.
And you see, it is this attitude of the court that empowers Godfrey Dame to delve into the realm of unethical behavior. Never in our lives have we seen the levels of high unethical behaviors we are seeing. That an Attorney General can pick up a phone and call a Supreme Court judge to tamper with a witness. How are you able to convince me this morning?
Call a Supreme Court judge, call a witness.
Call a Supreme Court judge to call a witness.
Okay.
And so how are you able to convince me that the Attorney General did not call any of the judges on the panel?
We don't know.
You know, Selorm, we can't tell. But we can't tell, but we can only but infer.
We don't know that.
Yeah, we can only but infer. We can only, and please, you conclude without me saying. Let me conclude. Yeah, we don't know that. We don't know that.
Yeah, so let's stay within the confines of what we know.
And I'm not saying it happened. I'm saying.
The discussion is degenerating.
No, we are almost at another touch here. So she's just landing.
I'm not saying he did that. I'm saying that how do you convince people? Because if the Jakpa tape had not come, nobody, even as a private practitioner, I would not for my life come to a point that I believe a lawyer would do that, and not even the leader of the bar.
But they were settling.
So, they were not settling.
No, they were settling. They brought in a third party.
What is the role of a Supreme Court judge?
No, I mean, he wasn't in the matter. He said he was related. He was, but he didn't have to sit. He wouldn't have to sit on the matter.
You know, Selorm, law and legal principle must matter. See, I conclude by saying that in the 31st December case, The judges who presided over that
quoting
case.
Cases. You are ending
No,
quoting cases.
I'm not quoting the case. In the 31st December case, the judges who presided were appointees of President Wallins. They had the golden opportunity to please their appointors. But you know what they did? They looked at modern democracy. And they say that...
But we've had that in this regime as well. We've had that in the Doma level case. The Supreme Court...
What is the effect?
But the Supreme Court ruled against the executive.
What is the effect?
No, the effect is that you can't do so again. The president today cannot do the same thing.
So that is exactly what we are saying. When it's against the president, the posture is different. So let me ask you, what is materially different in a constitutional interpretation case between Dumelevo and this matter, which has been decided under 2 weeks? I'm saying that in the 31st December case, in the Tufu and Attorney General case, in the Salah and AG case, these judges stood up. And today, we can boldly quote those decisions, and we proudly say that these are locus classicus. And every constitutional law lecturer will gladly take these cases. We are at a place that if the judiciary become abettors to politicians, we would have no democracy. And you know how the MPP quickly say, this is the rule of law. There is no rule of law when it's subject to the whims and caprices, and it is against judicial precedent.
Very well.
This
Thanks
is
so
an
much.
aberration.
Thank you so much, Beatrice. Let me take a few of the messages. This one from Chris from Ashalibuche says, the MPP members are obsessed with the thinking that they are first-class citizens, so they don't care about the law of the country except those that favor them. So they are inconsistent and they flip-flop all the time. He said you can't comprehend why they are still fighting for the majority status, but they wouldn't get that through the ballot box on 7. He said Beatrice Anan has been the Messi, Ronaldo in the studio. So you like a performance, and you extend greetings from Ramadan, the Adenta MP. Skelly says that these so-called lawyers of the MPP are a disgrace. Don't they realize a majority of the citizenry are having issues with this ruling? How do they sleep at night? And you say that Beatrice has been doing well. And also, Mahama Abdullahi says Beatrice is a lawyer, but she must be mindful of how she describes the justices of the Supreme Court. Yes. And then this one finally from Prince Henry says today most of the MPP MPs and communicators are running away from their own constitution, which said that once you have filed to contest as an independent candidate, or you declare to support an independent candidate against the MPP's candidate, you have forfeited your membership automatically. All right, so I don't think Atacha ran away from that. Atacha dealt with that. All right, thanks so much. We'll take a short break. We'll return and then look at the issue of health in the manifestos of the two parties. Thanks so much, Senior Atacha, who is Member of Parliament for Abuakwa South, served his time, and he's bowing out in glory. He's bowing out in glory, and he's been a member of the legal team for Afenyo Marking. Thanks to Dr. Justice Shremsrai also, who is far away out of town but made time to join us this morning. And Franklin Kujo is still here. Beatrice is still here. And then Dr. Ezekiel Obin Ajekum, MPP Manifesto Health Committee member, is here as well. So the next discussion looks at health. Thank you so much. We'll return after this break. Don't go away.
In the heart of our communities, change is not just a dream, it's a promise.
I don't have to worry about rising costs and taxes. Dr. Baumia's flat rate tax system is a breath of fresh air. It means I can keep more of what I earn and invest back into my business.
I've seen so many changes in my lifetime, but what matters most is to feel secured. Dr. Baumia's initiative for the elderly is to make sure we are not forgotten. He's giving us the exact care that we deserve.
With digital skills training, I am no longer worried about the future. Dr. Baumia empowers us to thrive in a digital world, making us ready for tomorrow's jobs.
Job opportunities are crucial for my generation. Dr. Baumia is committed to creating job opportunities and entrepreneurship. With his vision, we can build our dreams.
Together, we can transform our nation. Dr. Baumia's plan arranges policies. They are pathway for prosperity for every Ghanaian.
It's time for leadership that listens and acts. A vision for all of us, where every voice matters and every dream is possible. Vote Dr. Mahmoud Baumia.
Esoroho. Vote number 1 on the ballot.
Just in case you missed our comprehensive news bulletin, CNR, at 8 p.m., enjoy the repeat at 11 p.m. only on Channel 1 TV.
Dr. Baumia once said,
"But if the fundamentals are weak, the exchange rate will expose you."
Dr. Baumia, when your fundamentals are weak, your exchange rate will expose you. That time now, $1 to 4 cedis. And today, 11.5. The rate of depreciation. What are we going to say? $1. India, a Turkish near Medinica, ewo doors are the bremi. Embla me money deposit. Not dollar no. 6 cedis to $1. In August 2022, over $100,000. I have the evidence. Between 1,550,000 Ghana cedis, meaning the dollar was 15 cedis, 50 pesos. Where were the strategies?
The dollar, which was selling at 4.2 Ghana cedis in 2016, is today selling at about 17 Ghana cedis. Prices keep rising. Businesses are collapsing. Yet the so-called economic messiah is dead silent and totally clueless about how to fix it. Vote John Dramani Mahama for president. Trustworthy, honest, and reliable. Vote for change. Choose the umbrella. Vote John Dramani Mahama and the NDC.
You're welcome back to the big issue. My name is Selorm Adonoo. My guests this morning on this second segment, Dr. Ezekiel Obinna-Jekum, MPP Manifesto Health Committee member. The doctor is not PhD, the doctor is medical doctor. He's coming to talk health. Franklin Kujo is here, President Imani Africa. Beatrice Annan, who is a private legal practitioner and deputy spokesperson for the Jomama campaign team, is also here. A number of things have come up regarding the health proposals by the two political parties. We'll delve into that. But the two persons who talk about the health are politicians, really. And they've been following the campaign. They've been in the campaigns of the flag bearers. We will start off from there. Doc, welcome to the program. You've been on listening to the lawyers argue. Yes. I don't know if you have thoughts yourself on these legalities, etc.
I think in the end, what matters is that the Supreme Court is spoken.
Mm-hmm. You must all follow.
And whether or not we agree with the courts, it's the rule of law, and we need to abide by the rule of the Supreme Court.
Very well. So, what is your campaign now? You are in the flag bearers, Baumia's campaign team. What is the campaign at the moment, and what's happening there?
The team is in Ashanti region. Started last week, Monday. Dr. Baumia does every constituency. So, about 3-4 constituencies per day, depending on the distances between the various constituencies. So, yes, yesterday evening we were at Fomina. That was the last rally we had. And today we're supposed to do the Aguna, Agogo area, but he has a program in Greater Accra. So he would be in Greater Accra later today. So, about 30.
How's he combining his vice presidential role with the flag bearership?
Yeah, duties? He has to do the two at a time when matters require his attention, he, after campaigning in the evening, he drives back to Accra, and if we need to take a day or two off, yes, we take a day or two off. He attends to the issues as vice president, then he moves back.
You said you were in Formina last night. Formina has been a very popular, or it's been in the news for the past 4 years, actually. How are they, how did they receive the decision of the Supreme Court? I mean, generally, what do they think about what's been happening with their MP? Independent now MPP becoming MPP.
I think sometimes the issues are overflagged.
Do you understand what's happening?
The issues are overflagged. I mean, in Greater Accra, I get that sense, because when you move down,
you don't see all these Supreme Court matters playing out. They're just minding their business.
People are going about their businesses. Those selling are selling. Those driving are driving. Those going to their farms are going to their farms. You move in, you talk to them. It's what's on their hearts that they express. The major issue that I encountered, I observed, it's the roads in Ashanti region.
Yeah, the roads are bad or the roads are good?
That had been their complaint. But if you look at the work that has been done, at least I've traveled all the constituencies up until now. So at least I've seen the amount of work the government has done in terms of roads in Ashanti region. The main inner city roads in Ashanti region, the other constituencies up to Bekwai, the Manso, Edubia areas.
But the people in Ashanti often complain that they've been neglected for whatever reason, that the MPP government hasn't looked at them favorably, the way they look at the party favorably in elections.
I always say that there's nothing wrong asking for more. My village...
So the minimum, they don't even get the minimum.
My village, since I was born, I've seen an asphalted road for the first time in my village. And kids are going to school. Free SHS has opened doors to people. I have two village folks who are now in the medical school, so I wouldn't be the only doctor in my village.
But you don't even practice in your village?
If I choose to go and have some medical screening for my village, I wouldn't be the only one consulting. Very soon they have two other doctors joining me. And we've seen roads being done.
But has that got anything to do with the MPP government? It's because they've studied hard and they've passed and they're in the medical school. Is there any special
financial barriers? When I was born in the village, I started up to about class 3-4 before my parents.
So your point is that without a free SHS, these two people wouldn't have gone to the medical
in the
school.
village, there were a couple of students, children who were better than myself when I was in the village.
But they didn't have the chance.
They didn't have the opportunity to enter secondary school. And this time around, yes, opportunity is given to every home and every child in the country to have an opportunity to educate himself or herself. Aside that, our roads are done, our village square, for example, is done for us, but when you go there, people still want more. So coming back to Ashanti region, yes, I've seen first-hand, not reported achievements, first-hand achievements, the massive work in terms
last minute achievements.
Oh, the Bekwai road is not last-minute achievement. The Manso Edubia road applied on, it's not last-minute achievement. Kumasi to Obuasi road applied on, is not last-minute achievement. The Formina roads I saw and the other constituencies and all the development agenda 111 at various stages of completion. I had the opportunity to see the Tredea Hospital for the first time myself when we went to the constituency. And I've been speaking about
there are some hospitals that John Mahama left uncompleted. The Sewa Hospital, the military hospital.
It's not President Mahama's.
They say those hospitals have not been completed. 8 years.
Sewa is the regional hospital. It's been completed.
But it's in operation because the regional minister recently was complaining about
we are waiting to commission it.
But it's been 8 years because when Mahama was leaving, we understand it was in the latter stages of completion. It's taken 8 years and it's still not operational.
Then if we are to go back, then we would say that it started from President Kufuor. So it's part of the Eurojet project. It's not, if we have to credit anyone with the Sewa Hospital.
But the point I'm making is that it didn't have to take you 8 years to just take it from where Mahama left it. Because we heard it was in the latter stages of completion.
Where latter stages means?
80-90%.
80-90%.
Yes,
80-90% means that the building is over. You are done with the building.
But that's what we heard.
And you're rather stocking the building with equipment.
Even with the
military
hospital.
To get to 100%. No. They were not up to 90% because 90% means that your building is done, you furnish the place, you are waiting for the medical equipment to be in place.
But are you justifying why it's taking you 8 years to get to this point?
I'm not justifying anything. The only good thing at the end of the day is that after President Kufuor started those facilities, for 8 years they were not completed. Finally, we've seen some formality and finality to the situation, and those hospitals are ready to be commissioned for the benefits of those that need to benefit from those health facilities.
But why is it special? Does it appear, or it does appear really, that there's a special focus on Ashanti? Ashanti is your base. I mean, that's where the choir is. It does appear you are preaching to the choir.
There's no special focus.
You'll be there for like 2 weeks, or he's been there already for a week.
Exactly.
And
so again. Dr. Bawumia is touching every constituency. That has been his style of campaign. He started from the northern part of the country. He visits every constituency. He has stakeholders engagement. He's on the street doing his meet and greet, and he addresses a mini rally in every constituency. So if you have 46, 47 constituencies in Ashanti region, you end up spending more time. He's touching every constituency, and when he's done, he'll move out. He's done other constituencies. If you go to the central regions, around 27, he spent every day on each of the constituencies. So Dr. Bawumia is not, for example, doing 1 or 2 constituencies per day, as against the other regions where he did 1 constituency, 2, 3 constituencies per day. He's doing the same thing. We are doing about 3, 4 constituencies per day. But because of the numbers in Ashanti region, in terms of seats, that's why we seem to have spent more time there.
Because people say that the choir in Ashanti is not singing. And so the choir master must teach the song and teach it together.
I have a lot of videos on my phone I can play
about
to
the choir
you
singing.
About the choir singing and asking for backup. Some of us had to go and back up, for the choir. We don't know the part we play, but at least we're able to sing with the choir. And it was very interesting. I'm very happy with what I've seen in Ashanti region.
Great. Beatrice, where's your campaign? Where's Mahama?
So we came back from Western North over the weekend, and tomorrow President Mahama will be heading to the Northern region to finish the campaign, and then on Monday we'll be in the Eastern region of Ghana.
So he's going to the Northern region this weekend? Tomorrow.
Yes.
And he's going to spend just 1 day there?
Yes.
His opponent is spending
No,
days.
because we have been in the Northern region for more than cumulatively 12 days. So this is just, and we have a strategy. There is a reason we structure our campaign the way we've structured it. So tomorrow, there are some 4 constituencies in the Northern region, Mion, Gushegu, and others that he'll be visiting. And then on Monday, we will spend 5 days in the Eastern region. But I want to say that...
But before that, people think that the NDC is losing the North. The Bawumia effect is making the North fall to the MPP. and because it's from the region as well. And so that is a major worry for the NDC.
It's not true. There is no Bawumia effect in the North. What you have is vote buying in the North.
Really?
No, there is no Bawumia effect, because you know why. And I'm happy we are coming to talk about health, because health is economy. And so sometimes, and I was listening to Doc when he was speaking, and in this election, the distinguishing feature is that the people you are campaigning to, whether in the North, in the Ashanti region, in the Greater Accra, what is the quality of their lives after you took over? And so you can be in Ashanti region, but you were speaking to a group of people that their lives have been made worse. I saw that Dr. Bawumia went to some Churchill station. In that Churchill station, even though it was in Ashanti region, they are having to buy a gallon of petrol for 75 cedis from 14 cedis in 2016. The people of Ashanti region deserve better. And so they can be the choir, they may be singing, but on an empty stomach.
But the song will still play. The song will still
Yeah, but on empty stomach. So for us in the NDC, when we think about governance and we think about leadership, we don't think the people who follow us are just mere followers who do not deserve better lives. We think that we have a responsibility towards the people that we seek their mandate, and it's reflected in what we do. So let me give you a typical difference between the NDC and the MPP. The MPP does not believe that if you don't, they believe that if you don't vote for them, you don't deserve development. And I can give you examples. First of all, in the Kumfi, the president said, you didn't vote for me, you cannot come here and ask for development. In Aplau, he says, you don't vote for me, how do you expect me to complete your e-block? In Pong, it was practically an altercation between the president and the chief. We in the NDC...
But the president has also said that he will continue wooing the voter lady until the lady agrees to his proposal. Wooing the lady means taking development there.
And then when the voter lady had an issue of the Akosombo spillage, government did practically nothing about it.
But the president went there.
To do what?
President
And to do
move
what?
to the place.
What do they
At least
want?
first to commiserate to the people,
And then
to
second,
show them love,
and then second,
and then now they are constructing a number of buildings.
Wait.
No, there's building
who
construction
told
there.
you that?
No, we see that the number of buildings are being constructed for the victims.
No,
so that's showing the lady love.
The devil's advocate must be done in
No, I'm
within
stating
the
facts.
context of reality.
I'm stating facts.
What we did, because you see, and I stayed in Ashanti region for 4 years. I learned how to speak Tree. Yeah, I learned how to speak Tree very well in Ashanti region. So when the NDC, you mentioned the NDC in Ashanti region, you can't associate us with the Kejetia market, with the Tafo market, the Sawaso market, the Tonsu market. When it comes to E-blocks, we gave Ashanti region 22 of the E-blocks.
Many of which were left in the bush, were not completed.
You see, the concept of building in the bush is the reason why the government has sunk 932 million cedis on the cathedral, where the passport office, the judge's bungalow were demolished for nothing. Because you know how you develop, you have had the benefit of traveling. When you want to develop, especially a monumental project, you don't bring and demolish building, you take it to the outskirts. I was on a media outreach in the eastern region, and a place where we took the E-block and they said it's a bush. I'm told now you cannot even afford to buy land there.
Because it's become
That is
prime.
how you develop. You don't demolish things. So there is a vast distinction between the NDC and the MPP. And when they go to Ashanti region in 2020, when Nanado went to Menchia, he could not mention a single thing they had done for the Ashanti region. He said, Nana, Mama will not know appointment.
Yes, but it's good. Appointment is good. And he just said that a lot of roads and things are being done there.
Every region
by the constitution, must be represented.
Must be given appointment.
But if more of the people
if the people of
good.
Ashanti region, I was expecting that the discussion would be that.
How about the airport, the Ajiman Prempeh airport?
Who started?
No, but they've completed. It's not fully an international, international airport.
Who started?
And they are finishing a lot of the roads.
I think that it's not just the Ashanti region, but generally the MPP does not respect the people of Ghana. They believe, and I am fortified in my belief that they believe that let's impoverish the people. Let's make the standard of living so unbearable so that when it's election and we bring money to them, they can probably feel a certain short-term ease. Because you see, it is an eyesore that we will come there, that in 8 years, the discussion will not be about we have been able to achieve and I say that when it comes to the issue of campaign, health, economy, we don't have to politicize it. Because you see, when you fall sick and you're going to the hospital, nobody will ask you who built the hospital and whether you're an NDC or MPP member. But this government politicizes everything. You know, it's election. So let's go to Ashanti region and spend 2 weeks there. Let's spend more time and resources in Ashanti region. Yesterday, I spoke to Ashanti Regional Communications Officer who told me that they give you a shirt and give you 200 cedis. And I've seen the video of some of the guys on TikTok saying that I've seen videos of Ekorebusu sharing rice.
But you all do it.
We do it well.
It's a blatant lie.
It's not true. It's not true. But you share t-shirts. Everybody shares t-shirts. Like the one you're wearing.
It's blatant. I'll give it one. I want one in the car.
He has one in the car. He'll give it to you.
It's a
You know why he has one in the car?
Why?
Nobody wants to wear
No. What are you saying?
I don't have.
I can show you the videos. And if you know Dr. Just 1 minute. If you know Dr.
Let me just take Franklin. Hello, Franklin. Yes, the politicians are talking. You have a doctor and a lawyer who are now doing politics, leaving the political scientists to do other things. Interesting. We're just trying to look at the campaign generally. From where you sit, how do you gauge the mood? How do you gauge the movement of the parties in respect of what they are promising, etc.? Imani recently had an event on manifestos, etc. Just brief thoughts.
Well, I think the campaign is becoming interesting. Even though it appears to me the various candidates, so the leading candidates are quite tired. I think though that I think they are covering their bases quite well. I see that the gaps that I saw from the beginning of the year in terms of the leading candidates is becoming a bit narrower. And I think that getting to the last stretch of the elections, there's going to be a lot more activity, which I suspect is the reason why Dr. Bawumia is in the Ashanti region and is going to invest a lot of time there, because you see, in Ashanti, if you don't do so well, then you have challenges. Some of the things I've seen so far tell me that some of the swing regions are going to be difficult for the NPP, for sure. So they need to double up. They really need to double up quite well. But substantively, speaking about the various promises, it looks to me, when it comes to health, because I thought you were going to discuss health.
Yes, health, yeah.
There are certain signs that the healthcare campaigns are quite, promises are quite interesting. I see the trying to do the certain one thing. It's a beautiful idea. I seem to be so clear about that. And maybe we recommend that they should have a clearer funding path and maybe optimize the use of public-private partnerships. I would be happy to have the private sector actually take 70% of this hospital. Because the problem with our country here is that the public sector will invest, build the hospitals, and then it gets run down. Look at Kofanochi, look at Kolegu, gets run down. So this Agenda 111 thing may be nice and fine, but I think if they don't optimize it by bringing in some significant private capital, and it must be done transparently, because we've seen that this administration has paid lip service to all these procurement issues. You'll be surprised. I mean, we studied over 1,000 procurement contracts. Only 5% or so could pass muster that were done right. About 5% of those heavy money, right? All of them were just done. It's one of the sources of corruption. So once we expect that they should do private sector collaboration, it should be done transparently. I think that is important. On the other, I think the John Mahama campaign, the promises in the manifesto of NDC are quite very interesting, really. I see that they are bits and pieces, but when you hang all of them together, they tell a certain story, that they prioritize the person, as in the patient, the people, the care, a bit more than just putting up existing infrastructure. But of course, the NDC is also saying they'll put up all kinds of infrastructure. They're going to turn a lot of these, they'll build some of these health-related universities, or some of the existing ones will be turned into a bit more bigger institutions to facilitate healthcare education. And you see, trying to sow seeds of healthcare projects across the entire country. And as I said, if you put all together, it tells a certain picture, which culminated to what they call the Mahama Cares. Yes. The Mahama Cares thing is a fine idea, but that also needs a lot of significant money and all of that. Yeah.
Great. Thanks. So now, Doc, yes.
You wanted me to?
No,
you couldn't hear me.
No, I heard you. I mean, so you landed well. So just where you ended, I'm bringing in Doc.
All right, thank you.
So Doc, I mean, talking about the MPP's health proposals, we've heard quite a number of things. But what will you consider as the top 3 or top 4 proposals in your manifesto?
So we're already in the process of delivering quality primary health care. We are in the process of already delivering universal health coverage in terms of accessibility, quality and financial burden to the consumer or the Ghanaian. So it's just a continuation of what we've started and the add-ons.
Okay.
We talk of self-service delivery, talk of the number of doctors you have, number of nurses and allied health workers you have, how quality in terms of services they give, and the quality of services will come from training, and secondly, motivation of the workforce and the facilities they work in, vis-a-vis Agenda 111. So we will continue with the provision of the health facilities for every Ghanaian to have access to quality healthcare at the base of our healthcare, which is the level 1, comprising of chief compounds, health centers, and the district hospitals. And of course, we promise that every region would have a regional hospital. So
every
we can
district
clearly
without a hospital will have
all the districts without hospitals.
But Agenda 111, it's been interesting
hospitals.
how it has evolved. Initially, it came as a promise to be delivered in 1 year or 18 months. And since then, we are in the 4th year or 5th year.
I always say that.
The point is, when the promise was being made, what was the person thinking? What was the president thinking? He thought that he could deliver this in 18 months, or because an election was coming at the time.
My understanding of what the president said was that in 1 year, we are going to start hospitals. In 1 year,
He said he was going to deliver the hospitals in 1 year from the time he was speaking.
Whatever being the case, I always say that up until the president made that categorical statement. How old was Ghana? But Ghana still had over 88 districts without hospitals.
Because we kept creating districts.
If we were about 55 plus, or even up to 60 plus, and we had 88 districts without hospitals, and someone is using about 4 years to make sure that something we were unable to do for 60 plus years, we are able to achieve holistically.
So you see, I mean, the distinction has to be made. So, for example,
within 4 years.
So, for example,
irrespective.
Let me just make this intervention. Western North, as we speak, doesn't have a regional hospital, but before, Western North was part of the Western region.
Exactly.
And Western region had a regional hospital.
Yes.
OT, as we speak, doesn't have a regional hospital. But before, it was part of the Volta region. And the Volta region had a regional hospital.
Very good.
So to say that we are over 60-something years and the number of districts don't have it may not be entirely accurate, because we have created and diced up the places. And so that happens.
Even if we were to work with the previous regions and the previous districts, we still would have over 60 years of existence as a country without district hospitals. Even if we were to go back and work with the previous numbers or previous number of regions, we will still have the same story. And then we came ahead with the creation of new districts and municipalities and the regions as well. So what I'm saying is that even if it's going to take the country, Ghana, 5 years to make sure that we've tackled the entirety.
The point is, that wasn't the promise. So somebody...
What's important to me is that even if the promise was made to deliver within a year, and it's taking 4 years, 5 years to deliver holistically the monumental, health facilities across the country, that's a plus as a healthcare worker, because I've seen people without access to even cheap compounds and the lives and the health risk it poses to such population. So even if it's going to take 5 years for the country to make sure that we have those facilities, to me it's not a bother. We can go into the nitty-gritties of the promise, at what point in time was made, how long the president
what is important
might
is that
have said.
the project is ongoing.
In the end, it's ongoing and the people are going to benefit from it. And I've seen those facilities with my little rounds with the flag bearer. And to me, as a health worker,
how many of them do you have completed, or what was the statistics on
our promise was to deliver from 30 to 45 by the end of this year. And there are a lot that already we are done.
Have you done one?
I went to Tredier. Tredier is done. Achansi is done. It's not commissioned. It's done. That's why I'm saying that before the end of the year, I know that we're able to commission at least 30 of those facilities.
Okay.
So yes, we are looking at making sure that primary health care, it's done and done properly. Universal healthcare coverage, yes, you give people opportunity.
Universal healthcare, where are we on that?
We are almost through, because universal healthcare coverage tackles 3 things: accessibility to quality healthcare. When there is accessibility and there's quality, and the cost of the healthcare does not become a burden to the person accessing the healthcare. So in terms of accessibility, that's where Agenda 111 comes in. In terms of quality, the trainers and trainees you have producing the healthcare workers, and the quality of equipment and deliverables at the various facilities. And then the financial backbone of our healthcare delivery, which is the National Health Insurance Scheme, making sure that people get access to basic health needs without a strain on their pocket. So in terms of the universal health...
As in the financial access, NHIS, I hope you hear reports that people go to the hospitals and they are just giving paracetamol.
So that's not really
working. What actually is happening is that there is out-of-pocket payment made. Now people have accepted it, so they actually do not complain. That's one. Number two, you are told when you go there that A, B, and C are covered. The card, the folder, consultation covered, but you have to pay for the tests. You have to pay for the medication. And people take it like that, and that's fine. So in terms of cost, I'm not so sure about the NHIS absorbing the cost entirely. People still make a lot of out-of-pocket payments.
That's where, personally, if I'm to speak as a professional, I believe NHIA and stakeholders should do a bit more. Because I'm privy to facilities where before NHI brings people to come and, lurk around and audit a few things, they ask the pharmacists, please, when they come, don't collect monies because NHI guys are here. The moment the guys leave to NHI, the co-payment starts. So the issue is the co-payment and how NHI can crack the whip. Because yes, they take the monies from the patients and they still go back to fill the forms for NHI claims. Yet NHI keeps advertising the services and the conditions that it covers, the tests and medications that it covers. Of course, if you come to me and you want an American brand of paracetamol, for example, or you want a UK brand of paracetamol, the stipend NHI gives the facilities is not up to the standards of American
medicine.
Yeah, exactly. For example, which you would have to add something to. Take out what NHI would give you, and then the top up will be done by you. There's co-payment in terms of what the servicing or the facility is giving you. But like I said, I'm privy to facilities where women will go for cesarean section, and instead of the whole package being part of NHI's or NHI levies or stipend, facilities still make the patients buy drugs, sometimes to the tune of about 800 cedis.
Yeah, because what the NHI pays them it does not reflect the market conditions. So
how then do you tell your pharmacist not to take money when NHI guys are around? If you believe that what NHI
but that's what you are saying. I'm not privy to that.
I'm privy to that. So I'm saying that yes, the scheme is working. There are advertised conditions up to about 95% of all conditions that at least we see within our terrain is covered by NHI, including the tests and the laboratory tests we request as medical practitioners, all covered by NHI. So if someone goes ahead or goes to the pharmacy or goes to the lab and the person is being made to pay, I believe we all need to come together, stakeholders, media people, let's expose these things and let's get NHI to crack the whip. But of course, the scheme is working and it provides, even if you pay, remember that the same facility will go back to NHI for something you've paid for. They'll still go to NHI and make those claims.
Very well. Beatrice, universal health coverage says NHI is working, Agenda 111 facilities ongoing, and the system appears to be working. What is your top three?
Are these the top four?
If I have time, I could continue.
So top three, top four promises that you're making in there.
So listening to Doc, I think that every Ghanaian should be very sad.
With all the nice things he has said.
Yes, it's very sad because you see, to the NPP, our health is politics. Our health has to do with sloganeering. And it matters not what the outcomes are. We have to have speaking points for debate. I am a young politician. And so when John Kuma passed on, I became very devastated. I think my Facebook post consistently even showed how my levels of devastation. Why do I say that? When a whole Minister of Health, Finance, Deputy Minister of Finance, was in the Ashanti region and had a medical emergency, he had to be rushed to Accra and subsequently be flown outside. And then even before they could get to Accra, unfortunately he passed. This man is not an NDC member. And that is the danger when you play with our health. You remember that although you can today, Asante Bedietuo is sick in US. He has the dollars to be in the hospital in US. Can you imagine if it happened at the time we had COVID and the airports around the world was closed and you cannot even fly out because you have millions of dollars? What becomes of your status of health or your health status?
But he was in the US, so he would have been taken care of. That didn't happen to him in the US.
Yes,
so
but that's what I'm saying, that if it had happened here,
you would have been taken care of by the UGMC, by Kolebu, by Konfanochi.
I'm happy the hospitals you are mentioning.
Kolebu.
Yes,
Kolebu has been there since.
Yes, I'm happy about it. Because you see, before we can even talk about what the party's manifestos should be, it's important that you evaluate the party's manifestos within the context of our current health status. So that it's not because we are going into an election like the president did in 2020 and just came out to say we will build an agenda 111 when you had Shama being commissioned and there is no hospital in Shama, and the La General Hospital, you still have the same story. It is because of the niceties of language and for people like Doc to have speaking points when they come on the show. It has never been about our health. Because people blame us, the NDC, because we build hospitals without attaching slogans. Who says that I want to achieve universal health coverage for my people? And for some miraculous reasons, I've identified that 88 districts do not have hospital. But in 4 years, or in 8 years in being in power, I cannot pinpoint 20 which I have completed and operationalized with the view that my people must have access to healthcare. What we have are speaking point for communicators that we are building Agenda 111. What is the report by the Ghana Harmonized Health Facility Report, which was published by the Ghana Health Service, and he should be said as a medical doctor. The report says that only 5% of facilities in government in this country has full complement of basic consulting room. He says that when it comes to 24-hour medical service and nursing staff, which they claim we don't need the 24-hour economy because hospitals are operating 24-hour. It says that you have these 24-hour services are not available in all facilities that provide emergency services, with availability ranging from 81% of regional hospitals to 64% of district hospitals, 43% of other general health, and 40% of polyclinic. And this is where it even gets at 99% of district hospitals do not have MRI services, and 15% hardly do any routine maintenance. So that is the current, and it's even more damning, but for time, I would have showed you the statistics and the report.
I wanted you to quickly touch on the Mahama case.
Yeah, so, but that's what I'm saying, that, so before a party comes out with the manifesto, it must not be because you want to win votes. It must be because you want to address the current systemic issue. And when it comes to the NDC, we have the track record of investing $243 million in replacing medical equipment. And I can rattle for you the number of hospitals the NDC has built, from the UGMC to the Bank of Ghana Hospital, to the Maritime Hospital, to the Bonkatanga Hospital, and so many hospitals that we rattle. In the area of health, I think that the NDC has no match. And so when we come to our manifesto and we say that, looking at what has happened from 2020, about how people with chronic diseases have been treated in this country, that the president will be flying a presidential private jet with 69 million cedis in 9 months, but we cannot find 4 million to repair dialysis machine or pay for debt, that we just have missed the priority. It was important that to address that stopgap measure, we bring what we call the Mahama care, so that people who have chronic diseases like kidney failure, where they'll go for dialysis, cancer, sickle cell disease, diabetes, hypertension, and heart diseases, there will be a dedicated fund to attend to them.
But now they may not need that, because from 1st December, Dr. Bawumia and the MPP or the government is beginning to absorb the cost of dialysis
Only
treatment,
dialysis,
and it's for free.
Yes,
and that's a huge.
They are absorbing the cost of dialysis, which is
only deals with the rest of that.
No, only the NHI doesn't take care of cancer and sickle cell and diabetes and hypertension and heart disease.
Leukemia, childhood cancer, breast cancer.
That's childhood cancer. But
when was it?
The
the highest number of cancers, breast cancers, childhood cancers.
So we are saying that when you are addressing the problem, you don't address it for elections. This government has been in power for 8 years. The people who had kidney diseases and were going to dialysis have lived all their life. In fact, because of government's own negligence, many people died. At the last check, when Kolebu closed, about 17 people lost their lives. Why is it that you sat down for 8 years? But 5 days to an election. The program is beginning on 1st December, right? So 5 days to an election, all of a sudden, you can go for dialysis for free.
Very well. Let me.
But he had a lot of time.
No,
you know, because I rattle, you think I have a lot of time.
But you're pushing out a lot of work.
You've done more than 15 minutes.
Oh, no. You just done 4 minutes.
I appreciate my sisters.
Why are you doing this?
He did 11.
Why are you doing this 1 week to election?
I appreciate
this is just to catch votes, isn't it?
She made an emphatic statement.
So you have just 2 minutes on this.
It's for political expediency. Political expediency.
Yeah, but if you have 4 years and 1 week to election,
I'm saying that if it was for political expediency, I would have wished my government would started the free dialysis somewhere October.
Yeah, but
by October to December, you'd have had almost everyone on dialysis benefiting.
Yeah, so the
it is not a matter of political expediency.
But it is what?
How many of them within 6 days can actually benefit? Exactly. How many of them within 6 days can actually benefit from the free dialysis policy?
But as compared to you,
we told the whole world that we were piloting what we started in June for 6 months, and after 6 months we will come out with a clear
so why don't we do it in January?
And we have done that. The 6 months is the ending of November.
Yeah, but if you add 1 month
we should add another month. We should have another. We should have another.
It would have been cleaner.
Just 1 minute on what my sister said.
No,
just 1 minute.
The source of funding.
Yes, the NHI is going to cover it. We've done the mathematics up to the tune of about 54 million per year. We've done the mathematics.
But NHI is struggling. NHI is on its knees.
NHI is on its knees?
Yes.
How's NHI on its knees?
Because many health facilities have not been paid for months.
For how many months?
For months.
For how many months?
6, 8 months.
6, 8 months. I bet to differ. But on the issue of what my sister just said, I appreciate the difficulty the NDC has. Just to be clear and to tell the NDC, sickle cell is already being covered by the NHIs under this government. What the sickle cell disease children need is what we call hydroxyurea to make their lives better, to prevent the strokes they usually experience and whatnot. It's being covered by the NHIs.
With co-payments, you just complain about.
The cancers she mentioned. NHI already caters for certain forms of cancers. The kidney disease, liver diseases, and all that she's mentioned, they are already covered by the NHIs. Hypertension, diabetes, covered by NHIs. So NHIs is already covering all the things we claim.
Prostate cancer, not covered under the NHIs.
Prostate cancer.
But that will be covered by the Mahama case.
So Mahama will come and tackle prostate cancer.
A lot more
but
things.
Even the question, at what point does it kick in? Because when someone comes to me, if you come to me today, you are coming to describe.
But they don't come to power. So when they come to power, they'll start.
It doesn't really
but when you promise free SHS,
free SHS is cast in stone.
What I mean is when you came to power, you started in September.
If you allow me, free SHS is already cast in stone. There's already a vehicle providing financial support for healthcare delivery. So if you come to me, before I diagnose you to have that renal failure they want to cater for under Mahama care, all the steps you've gone through, who's going to cover?
NHIs will cover.
So NHI covers. I diagnose you to have cancer, then you move on to Mahama care.
Yeah, if that's a different vehicle.
Come on. So NHI is already there, providing a vehicle for assistance for you to be diagnosed. Except that the moment you are diagnosed, then you move to Mahama care.
Well.
If you have anything to support, it is rather to strengthen the NHIs. That at the point of your entry into the healthcare system, up to the point of your diagnosis, which the NHI is going to cover, then we move on to a different scheme for the scheme to give you the medication and treatment.
Frankly, just 30 seconds
to wrap this up. Let's just throw something in because people want to hear something during elections.
Franklin, just wrap this up for us in 30 seconds.
Well, I wish the parties quite well. I think Ghanaians are very much aware of why they are going to vote in this election. And the number one issue is the economy. Let nobody deceive themselves that the economy is not the front and center. I mean, the economy does well. People will be able to take care of their healthcare needs, really. I mean, sometimes the state can just provide some support. So Ghanaians should be well behaved at the elections, I should say, and then just vote according to their conscience, especially on the
Very well. Very well. Thanks so much, Franklin Kujo. Thank you so much, Dr. Ezekiel Obiajikum, who are about to drive from Kumasi to be here. We appreciate that. And Beatrice Annan, Esquire.
I thought I'll have some conclusion.
No, you finished.
Because I have a chart from the NHIS.
NHIS.
Where you presented to Parliament.
NHIS.
Showing that
all right,
even in 2022,
thanks so much, guys, for doing the listening. Catch you same time next week.